welcome to another program on Law and Order, the program that highlights an area of law every Friday to bring you expert opinion on that area of law. Now today, we picked another area of law which we haven't discussed in the 3 years of history of this program, and that is very important to all of us who does some kind of a job or give some kind of a job. I'm talking about employer-employee relationship, or in a broader scope, it can be called the labor law. And to discuss with this area of law, I have a specialist in the area of law who is also a very experienced labor lawyer. He is Udara Tillekawardena, attorney at law. Udara is joining me to discuss in this area. Udara, thank you very much for taking time off with your busy schedule. I know you're all over Sri Lanka, but you took time off to come to us.
It's my pleasure.
It's my pleasure to be here.
Give some ideas about the industrial law.
Thank you. Yeah, industrial law is, I think, the technical term I should have used.
Yes.
Now, this is not a subject we can finish in one program or several programs, but we will try to do as much as possible. Just tell me to start with, in the legal definition, who is an employee and who is an employer?
Yeah, if I say that who is the employer is the person or an organization who will give the employment to other people for their jobs.
Yeah.
And employee means who is the person who works under the employer for a salary or a remuneration. The word salary is a thing which you take home, but the remuneration means the salary with all the benefits. In the present context, people use the remuneration because the salary adds with other things. For example, even for the house rent, the vehicle and the fuel and other benefits. All the benefits comes under the remuneration. So in the present context, people use not the word salary, but they use remuneration. So a person works for remuneration is the person who is the employee.
Right. Now, is the legal recognition of an employee in working for a state sector? I know I'm asking this because you worked as a state counsel, and then you are working as a private lawyer for a long time now. The recognition of an employee in a state sector and the rights and liabilities of an employee in the state, is it different to that of the private sector?
Yes.
There's a
vast difference.
Yes.
Because the employees of the state sector are the government employees. But their package and the remuneration is totally different, and also they are in the pensionable service.
Right.
So at the end of their period after the retirement, they get the pension. But in the other sector, in the private sector, even the semi-government, they get the EPF and ETF even after the conclusion of their period. That means at the age of the retirement, they are getting the what you call the terminal benefits. That is the gratuity. So they are covered under Gratuity Act, EPF Act and ETF Act. EPF means Employee Provident Fund, ETF is Employee Trust Fund. So that is the main difference. But there are other differences as well.
What are those other differences?
For example, the state sector, there are some trade union differences.
Right.
And there are promotion and there are some hierarchies, but those are the differences. I think the main difference is that because they are in a pensionable service, but others are in a not a pensionable service, but at the end of their service, they are getting their terminal benefits.
Right, but the recognition, the rights attached. Other than that, that means the if I may use the term security of employment, is it more in a state sector or is it the same in the private sector? How has the law looked at this?
It's more in the state sector, but whatever I said and done, it's based totally depend on your employer. Because if in the private sector, if you are under a good employer, you are secured. But if the employer is bad and if he intends to hire and fire, so you are not safe. So in the state sector, you are mostly safe.
Okay, hire and firing, we'll come to that later when I'm talking about termination. Okay, what would be the the responsibilities in a relationship between employer and employee relationship? What will be the responsibilities and liabilities of the employer?
Yeah, as far as the employee is concerned, the employer will have to employ an employee. So he will have to give the employment, in short words, job. So once he gives the job, there must be a job description, there must be letter of appointment, and his terms and condition has to be stipulated. So then there will be no problem, because even there is a dispute between the employer and employee, it has to be in a written way. That means there must be a written contract. If there is a employment and employment concern, it's a written contract. It should be in a written way.
Yeah.
So then there won't be any problem, because if there's a dispute arisen between the employer and employee, if there's a written contract, the employment is secured.
Right. Now, you were saying about a contract. Now, you can employ a person as by way of a contract, as by way of a letter of appointment.
Yes.
And as you can recall, in the past, the letter of appointment was the governing
Yes.
letter. This contract came as a common thing much later.
Yes.
I mean, that's what I've seen. So, in these two, some people have this belief that letter of employment, when you have more than a contract, you are more secured with your rights. Is that true?
Yeah, actually, more or less it's same,
Yeah.
because the letter of appointment, you can stipulate each and every contract,
Right.
even the age of retirement, and your job description, your remuneration, and your workplace, and whether you can be transferred or not. Everything can be stipulated in the letter of appointment. Even the letter of contract also the same. You can have some clauses.
So there is no legal difference between letter of employment contract
No.
and a letter of employment.
Actually, letter of appointment is also letter of contract.
It's a letter of contract, right?
But
right. Different name.
even there are some places where there are no contract.
Yeah.
There is a written contract.
Yeah.
That is unwritten contract with the understanding of the employer and employee.
How does that happen?
Because you employ some person, but there is no written law, but there is no written contract, there is no written letter of appointment, but you work, you get your remuneration. At the end of the day, you are getting your salary, end of the month, but after a certain period, you are getting the retirement, but that is not very safe. That is actually not safe for both parties.
Why is it not safe?
Because if employer changes, say for an example, if son comes to the company and takes over the company, so the contract between the father and the employee is different to the son and the employee. So
Right.
even if there's a dispute, so he cannot go for litigation, because there is no written contract. So it's much safe to have a written contract or written letter of appointment.
Right. Then there is a type of employment, I don't know whether that is common now, called seasonal employments, which
Yes.
are recognized. What are these seasonal employments?
That is actually for a particular season, but actually for the season you get a casual employment. But in our country, most of the casual employment are permanent employees, because even though they categorize them as casual, actually they are permanent. The reason is they work every day, they come for work, they work for 5 or 6 days, they work for 1 month, even at the end of the period, even 2 weeks time or 1 month time, they get their wages. So even the employers are categorized them as seasonal employees. They are not seasonal employees.
Okay. One of the other things that have been questioned around, as you would know, is that you mentioned that whether it's a letter of contract or letter of employment, you have to stipulate the job description and everything.
Yes.
Now, obviously, as companies grow, they may have different jobs the same person will have to do, especially with the vast improvement of technology, new things coming. So the employer cannot think of everything that might fall in the job description. Now, what is not there in the job description? I'm talking about private sector. Say, can the employee refuse to do, saying that this is not in my description?
Actually, you can refuse, but this is not the practice. Because you cannot give every description under the job description or in your letter of appointment. But then the practice comes. In most of the companies, there's a practice, especially in the banks, you cannot give the entire job description, but there is a practice. So you have to do it.
What is the practice?
Because practice is that even if you have done it for a long period, even if your predecessor had done it for a long period, so that is the practice of the company. But even I strongly believe that job description cannot be given, everything cannot be included.
Has it been accepted in law or in cases that you cannot?
Yes, even if there is a dispute, even in the litigation, if there are no job description given, even the practice comes. So you can say that was the practice of the organization. But you have to keep this in your mind. But once you do a wrong thing, and you cannot say that wrong thing was the practice of the organization.
Can you give an example of
now,
that?
For an example, now, if you encash a check, right, But without having the identity card, the teller gives the cash to the customer. But you cannot say that is the practice of the bank. Practice is that you have to satisfy with the identity of the person. So these are the things.
Even say this, the fact that the practice is accepted in courts as well as by law, it is common to whether you are state sector or private sector or anything, right?
Yeah, but in the state sector, mostly the practice is not accepted because
Why?
everything is written. Because that's why the
Circulars.
financial regulations, the circulars are there.
So private sector also can, private companies also have memos or internal working.
But anyway, I would like to confine to the private sector because the most of the people need the opinion about the private sector.
Right.
Because now our country, there's a vast development in the private sector.
Correct.
And with that development, I think the labor law has to be improved.
Yes.
So I strongly believe that we have to think about mostly private sector. The reason is in the public sector, if there is a termination or if there is a litigation, there are no much opportunities.
Yes.
But in the private sector, if there is a dispute arose between the employer and employee, they can complain to the labor commissioner, they can go to the labor tribunal, and there are other institutes as well. So I think we have to think about the private sector mostly.
Okay. What is a probation period?
Once the employment is given, the employer can give certain conditions. That means the commencement of the employment can be given, and the other condition. Apart from that condition, there must be a trial period. That can be 3 months, 6 months or 1 year or whatever it is. So there must be a probation period where the employer can judge the employee whether he is suitable for the employment.
That's the idea of probation.
Yeah, that's the total idea of probation.
Yeah.
But I can go further. Even the probation period is given in Sri Lanka, there is no automatic confirmation.
Right.
At the end of the probation period, if you are working in the organization, even you cannot be considered as an permanent employment because there is no automatic confirmation. The confirmation has to be done by way of a letter. Even you can extend the probation period, or even without extending the probation period, you can work for the organization, but you will be considered as a probationer. There is no automatic confirmation in our country.
Right. What would be the general procedures in adopting disciplinary action in organization? Is it laid down by the law, or does each individual company has to lay its own disciplinary procedures based on some kind of a model law? How does it?
Yeah, in the most of the company there is a disciplinary procedure.
Right.
In the disciplinary procedure, there is a code of conduct. Some companies have code of ethics. Some say that is a code of conduct. Some say it's a disciplinary procedure. Even in the disciplinary procedure, you have to lay down what are the misconducts. So if a person commits a misconduct, whether there's a grave misconduct or a misconduct, then there must be a disciplinary procedure. So you have to adopt the disciplinary procedure laid down in the company. But if not, you have to adopt the procedure of rule of natural justice.
There is no model law set by the government or international labor organization for the private companies to follow? No.
But there are so many authorities. And even there are procedure.
Yes.
The normal procedure is if a person commit an offense, even if amounts to a misconduct, then first of all you have to investigate. But without making any investigation, without making an audit query, you cannot find out what the misconduct is. So once you find out the misconduct, then you have to issue a charge sheet. The issuing of the charge sheet can be done in 2 different ways. One way, you can interdict that person, that is he's out of employment. Interdict means you can suspend. The normal word is interdiction, or the suspension you can do it. And at the suspension, either you can do it without pay or with pay or half pay, whatever it is. So then you can have an audit query or an investigation, then you have to follow with a charge sheet. In the charge sheet, you have to give the charges which are preferred against the employee. So that you call the charge sheet. You have to charge sheet him.
That is disciplinary
Yeah,
procedure.
and
It's
no,
short,
that
yeah.
is not over
Yeah, I
actually.
know. Okay.
Then after the charge sheet,
Yeah.
whether he is in the employment or not, he has to give the show cause. Even the some people say the charge sheet is a show cause, either charge sheet or the show cause letter.
Yeah.
So once the show cause letter is given to the employee, he will have to give the show cause for the charges which were preferred or the leveled against him. So then again that is not over. So once the charge sheet, the answer is given, show cause is given, then the employee will have to satisfy the employer whether he had not committed or not. If the employer is not satisfied with the answers given by the employee, he can go further. He can have a domestic inquiry, or if not, he can terminate the services of the employee. Why I say that he can terminate the employee at that point?
Yes.
Because in Sri Lankan law, in the settled law in our country is that you need not to have a domestic inquiry. Even without having a domestic inquiry, the services can be terminated.
Right.
But
Not in India, for example, am I correct? In some countries it's not.
yeah, some countries you must.
Right.
But anyway, in our settled law is that we need not to have a domestic inquiry.
Right. Now, do you think, very important point, because this is an issue that comes up in labor courts, do you think that's reasonable?
I will say yes and no.
Why?
I will say yes,
Yeah.
because if the employee is satisfied with the outcome of the inquiry or the outcome with the audit query that he had committed some offence, he has all the liberty to terminate the services, because he need to go further.
Yeah.
He has to terminate because otherwise you can't maintain the discipline of the organization. And your organization is a profitable organization.
Right.
You have to earn the profit. So
Yeah.
you can't wait for such a long period.
Yeah.
You can terminate. But I said the answer was yes and no. Now I say no.
Yeah.
Because it's very unfair. Because you have to give a chance.
Yes.
Even the employee must get a chance to
Yeah.
give reasons.
Yes.
And apart from that,
Yeah.
there are certain things which to be satisfied.
Yeah.
Even the employer will call the witnesses, the employee can come with his defenses. So there must be an inquiry. So that should be a impartial domestic inquiry. So
Right.
that's why I said it is
Yes and no.
yes and no.
Right. Now, okay, there are punishments, like there are offences in any disciplinary code in a company, or wrongs as we call it, which are grave
Grave misconduct.
as well as minor misconduct.
Yes.
Now, for what you said, yes, that is a disciplinary inquiry or just a audit inquiry, and then giving a punishment without a disciplinary inquiry, with the audit inquiry or the initial investigation for a minor misconduct does not seem to be unfair. Am I correct?
Yes, but
for major misconducts,
Yes.
where it can be terminated, if you do it with these only the domestic, without the domestic inquiry, it seems unfair.
yeah, if it's a major misconduct, it can be terminated. But for a minor misconduct, if a small thing, I think it's very unfair, because termination is the most grave punishment which can be given. That is the last punishment.
Yes.
So for a small misconduct, without giving any other punishment,
Yeah.
rather than giving a punishment like this, by giving a termination, it's unfair.
Right. Now, haven't they categorized anywhere in Sri Lanka by a case law or by law or gazette or whatever, that these are the offences that should be used in a company for termination as major misconduct, and these are minor misconduct?
Yes, it's a good question. Most of the companies
Themselves are
they are having their own code of conduct.
Right.
Even in their code of conduct or the disciplinary procedure, they have categorized.
Yes.
I think it is the best organization which they have categorized is the CTB. They are having their own conduct. It's a disciplinary procedure. Everything is laid down.
Right.
So CTB had a very good code of conduct,
Right.
or disciplinary procedure.
What about other private companies?
No,
So you
most of the
get so many.
private companies have their own conduct.
So why had the law left it open for people to do it on their own? Because the people not maybe following the uniform thing, right?
Yes, it cannot be followed.
Why
the
is that?
reason is
Yeah.
the yardstick is different, because in some organization,
okay.
in some organization, the misconduct is you can ignore it, But in some places, you cannot accept it. For example,
Yeah.
if you take a bank,
Yeah.
shortage of money
Yeah.
is a grave misconduct.
Grave misconduct.
But in another organization,
Yeah.
shortage of money is not a grave misconduct. But there are some instances where sleeping while you are in duty is a misconduct. There's a case law.
Yeah.
But in some places, you can even accept this. When
So
you-
that is why law has left it for
Yes.
the institutions to
Yeah, that actually that depend on the person to person and organization to organization.
and the trade
Yes,
they
and,
involved.
and even they are depend on the organization structure.
Structure. Right. So there is no supervisory body which looks into these things.
No,
Approval
no,
side. Not,
no.
not any
No,
supervisory.
even
Regulatory body.
I think no one can supervise it because you are having your own code of conduct for your own company.
Right. Now, one of the other things is salary anomalies which comes in and promotions. What is the guiding law in this in Sri Lanka for private companies?
For the private company, there is no guiding law, but once you take the remuneration, there are several laws governed by the remuneration because you have to pay the EPF and ETF for the whole earnings. But there is no such a law because that depends. Even the salary increments, even for the other benefits, the company have their own set of laws.
Yeah.
But whatever it is, whatever the remuneration, whatever the salary, everything is governed by the EPF and ETF Act. And there are other budget relief allowance and other statutory laws as well. But basically, every payment is subject to EPF and ETF. I am not talking about the other income tax and other pay tax. This is because I have confined to the industrial law. As far as the industrial law is concerned, your payment is subject to EPF and ETF. In some companies, even some employees, they like to not to subject to EPF and ETF because they are getting a good salary without deducting EPF and ETF. That is wrong. That means even there is a contract between the employer and employee not to deduct the EPF and ETF, even that is wrong because you cannot have an agreement against the law of the state.
Right. Right. But some people
I
prefer
think most of the people do this mistake.
Yes.
Because some with the if they don't know each other and if there's a good relationship between the employer and employee, they do not deduct the EPF and ETF, they give the full salary. End of the day, the employer get the full salary but without deducting EPF and ETF. The repercussions are, if somebody complains, even if the employee goes before the commissioner, or if not, if Commissioner of Labour find out that EPF and ETF had not been deducted, the employer in a difficult situation. The reason is, then the employer has to pay the employee's contribution, say for an example 8%, employer's contribution 12%, altogether how much?
Yeah.
20%.
Yeah.
Top of that, the surcharge 30%.
Right.
So
That's
it's better,
50%, yeah.
even employee is a non-party, better to deduct the EPF and ETF, even to safeguard the future of the employee and future of the organization as well.
Right. Now, this promotions, which is the other question I asked, is there like a guiding law for promotions or in private sector? Because what we have seen in general is that in state sector, your seniority proceeds.
Yes.
And in private sector, we see somebody who can come from nowhere and have occupy entry level position, but can jump to the CEO's position or whatever, depending on the efficiency overriding. In this private sector, what happens? Is this the correct law? Or is that practice accepted? That is based on your experience and efficiency, not experience, efficiency the promotions are given, or is it wrong?
Actually, that depends on the person to person and the capacity of the person and capability of the organization. Because if a person is capable, if he is performing well, he should be given a good post. He should be promoted. But actually, this is not a question pertaining to the industrial law. Actually, it's a more to the human resources. It's a HR because in the that depends on the HR policies of the organization. But whatever it is, if a person doing well, and he be promoted. So even actually that is the final task of the employer, because he has to get the best outcome from the employee. If employee is performing well, even though he is not having much qualification, he can be promoted.
Right. In your experience, what are the most contested industrial disputes between employer and employee in Sri Lanka?
Yeah, in the mostly as there's a breach of in the misconduct and a breach of discipline in the organization, they have taken so much of disciplinary action. And once you take a disciplinary action, finally, if you are not satisfied with the explanation given by the employee, the services of the employee can be terminated. Once the employee services be terminated, then the employee has a right go for litigation. That is, you go to the tribunal under section 31B of the Industrial Dispute Act. Then you will have to have litigation. Then you will have to file an application. Then the employer will have to file an answer. Then
and the trial proceeds.
Trial proceeds. The worst part of it is that if there is a termination, if the termination is accepted by the employer will have to start the case and justify the termination. So the employee need not to spend much, but employer will have to spend his time, money, energy and resources.
Udara, Tillekawardena, thank you very much for joining Law and Order today.
Yes.
Very insightful thoughts on a subject we have not touched, and we wish you success in whatever you do. And thank you again for coming.
Thank you very
Law
much.
and Order.
Thank you.
Thank you very much. Thank you. Please. We will join Law and Order next week at the same time with another interesting topic. And if you miss our shows, you can go to our website channeli.lk and watch them all over again. Good night and have a good weekend.